So I plan to speak for about 1 hour. I'll be talking about a famous dispute that arose in the 1960s during decolonization in a case between Ethiopia and Liberia and South Africa over the status of a territory called Southwest Africa. At the heart of the dispute was the question of apartheid, namely whether South Africa could channel its apartheid laws into Southwest Africa, which today is called Namibia. It was renamed by the UN General Assembly in Namibia in 1968. The dispute, which I will explore, in 1966 arose because Sir Mohammed Zafarullah Khan, one of the judges in those cases, did not appear in the judgment and did not appear to recuse himself from the case either. And because the judgment, there was a tie, the president of the court, that's Sir Percy, the Australian judge, essentially had 2 votes and swung the decision in favour of the respondent state, namely South Africa. And it was very controversial because it was seen as a victory for the apartheid regime. But I'm jumping ahead of myself at this moment in time, just giving you the background. Before I delve into details, just to let, as Michael mentioned, I wrote a book on the Palestine question and working on a forthcoming book on partitions. And it was in this context that I came across the name Zafrulla Khan, who played an important role challenging the authority of the United Nations to partition Palestine in 1947, and 3 months earlier being involved as a representative for the Muslim League in British India in the argument for the creation of Pakistan during the Punjab Boundary Commission. And much of this research for the paper, which is forthcoming in the Asian Journal of International, and I hope eventually a short monograph, biography of Zafrulla Khan, is based on research at the National Archives here in Kew in London, in which I came across a very startling telegram from the British Foreign Office legal advisor to the United Nations, the United Kingdom delegation in New York, expressing concern that they were considering nominating Zafrulla Khan to be a judge at the International Court of Justice. So this piqued my curiosity. I thought there must be a story here, but at that time I was doing other work, so I just made a note and moved on. And it wasn't until I read a biography of Sir Percy Spender by an Australian historian, and had occasion, being in Singapore, to visit Australia, that I got to travel to Canberra and look at the Australian National Archives, and most revealingly Sir Percy Spender's papers in the National Library of Australia, which is not subject to any official Secrets Act, and lots of very interesting things that shouldn't be there. I'll come back to this. So in today's lecture, I will begin by looking at Zafrulla Khan. We'll explain who he was and the important role he played in decolonization, because before he was a judge, he was foreign minister for the government of Pakistan, and in that role played an important role in many of the early United Nations debates on decolonization. And it was because of that role that he'd get into a spot of trouble during the cases when he was a judge in the 1960s. After exploring Zafrulla Khan's role in decolonization, I will look at Sir Percy Spender and another judge, Gerald Fitzmaurice, with whom he would sit uncomfortably in the courts in the 1960s. I'll explore their backgrounds. Sir Percy Spender was also, for instance, the foreign minister for the Australian government. At the same time, Zafrulla Khan was foreign minister for Pakistan, so they took opposing sides early on in this debate over the legacy or the right of colonialism, or the illegality of colonialism. Then I'll look at the Southwest Africa cases. Then the Recusal controversy that I referred to will become, I hope, a lot clearer. So let me begin with Zafrulla Khan. Zafrulla Khan was born in that part of the Punjab that would form part of Pakistan after partition. He was born in 1893 and passed away in 1985, a few months before Sir Percy Spender passed away. Zafarullah Khan was a prominent member of the Ahmadiyya Muslim community, and because of his faith, that there is suggestions that he was not able to retain his post as foreign minister of Pakistan after some rioting in the early 1950s, and subsequently he went to the United Nations and became a judge. Zafarullah Khan played a very prominent role in the history of British India. He was a judge on the federal courts of India at a time when many of the judges were British. And he was, according to one scholar, one of the chief critics of British imperialism from the bench at that time, talking the early 1940s. In 1945, he became an advisor to the princely state of Bhopal and was involved in or attended the debates here in London on the India Independence Act. And there was a distinction made with some of the princely states, like Hyderabad and Kashmir. He was supposed to be given a choice of accession to either dominion, but in the end, that did not happen. He was then put in charge of presenting the Muslim League's case to the Punjab Boundary Commission and argued forcefully for the creation of a Muslim majority state, namely Pakistan, in that part of the province. Muhammad Ali Jinnah asked him to be his number two and appointed him foreign minister from 1947 to 1954. After that, he became a judge at the International Court of Justice until 1961. And then he became Pakistan's permanent representative to the United Nations. 1962 became the elected president of the United Nations General Assembly. And in 1963 was re-elected to the International Court of Justice, post he took up in 1964, and he retired from the court in 1972. And he lived in London between 1972 and 1982, passed away in Lahore in 1985. An interesting footnote to all this is that Nehru, Prime Minister of India, had asked Zafrulla Khan if he would be the judge for India, for the United India, before partition in 1946. So that raises the question. He lost the election in 1946, but had he been elected, he would have been on the courts, as a judge for India rather than Pakistan. I don't think it would have made any difference, however, to his decisions and judgments, because, for instance, in one of the cases concerning Portuguese colonialism in India, he sided with India, right of passage for India case. I should also say, I spoke earlier at King's College, London, and that was Zafrulla Khan's alma mater. He was a student there before the First World War. And Zafrulla Khan acquired a reputation, or has been referred to in the literature as a silent judge, because he didn't write many separate or dissenting opinions. He, of course, participated in drafting many of the judgments, but unlike other judges, like Fitzmaurice, for instance, who wrote over 200 pages alone in the 1971 Namibia opinion, Zafrulla Khan was short and to the point and precise. I should have also mentioned that in his first term at the International Court of Justice, Zafrulla Khan was elected vice president of the courts, and in his second term, he was elected the president of the court, and therefore he was responsible for the direction and drafting of judgments and opinions, the most famous one being the Namibia, 1971 Namibia opinion. And he therefore became the first Asian president of the International Court of Justice. Now, I mentioned that I wrote a book on the Palestine question, and this is a picture of Zafrulla Khan with Prince Faisal in 1947 at the United Nations General Assembly. This was when he became effectively the spokesperson for the Arab cause, which saw the United Nations proposal to divide Palestine as being very unfair to the Arab population of Palestine because of for a lot of reasons which I won't go into. But the important issue about Palestine at that time was its legal status. It was a mandate, a League of Nations mandate. So was Southwest Africa. And so many of the issues that were germane to both cases, that were germane to the Palestine mandate were also equally valid to the mandate for Southwest Africa. The only difference being that Palestine was classified as an A-class mandate, whereas Southwest Africa was classified as a C-class mandate. But don't worry if you don't understand what I'm saying. I'm going to go through the League of Nations system shortly, but just to highlight this point early on. And of course, Palestine was one of the first issues that the United Nations addressed in the context of decolonization, which I turn to next. This is a map that shows you, obviously, the world, and it shows you on the left, the key here indicates which countries became independent first. Some countries, of course, were never colonized. And you can see most of Africa and Southeast Asia goes through the process of decolonization after the Second World War. So this is really the time when Zafarullah Khan is a statesman for Pakistan. And he participated in many prominent debates, especially in the late 1940s, particularly with regard to Indonesia. In fact, as foreign minister to Pakistan, he advised the government to prevent KLM flights flying through Karachi to what was then called Batavia, the capital of Indonesia. He's also taking part in debates in Algeria, and there was a bitter civil war with France for 2 decades. He participated in debates on the independence of Morocco and Sudan, and came out strongly in favor of the nationalization of Iran's oil facilities, which greatly upset the British government at the time because they had the concession. Now, one factor that, of course, we have to be aware about is that the Cold War is really getting going in the late 1940s, and so what we see emerging is what South Africa would complain about was this idea of a third world bloc of countries, namely the Afro-Asia bloc of countries. And so Zafarullah Khan became very much associated because of these powerful speeches that he gave in the United Nations with these bloc of countries. And so he was seen as suspect. He became seen as suspect by some British officials, including Sir Gerald Fitzmaurice, because many Eastern Bloc countries, the USSR, later China, and later Cuba, were also aligning themselves with these countries. And of course, Britain was still a colonial power in the 1940s. Britain hadn't given up the idea of, although Britain had left Ireland and India and Palestine at this stage, Britain was also establishing what they call the Central African Federation of Rhodesia, Nyasaland, and Malawi, which some people described as a state that was all that different to apartheid South Africa. So these debates were going on, and of course, in the 1950s, Sir Gerald Fitzmaurice, who was working in the Foreign Office in this country and would have been defending Britain's colonial record in these various controversies by arguing that the United Nations, the ICJ, other institutions had no jurisdiction to look into these matters. For the same reason, Sir Percy Spender would be making similar arguments with regard to Australia's possessions, such as New Guinea and Nauru. Another issue I just want to raise at this point, you'll see Ethiopia and Liberia were not formally colonized, although Mussolini had an attempt in the case of Ethiopia. But the Empire of Ethiopia, as it was known, and Liberia are important because they were members of the League of Nations. And therefore, as we'll come to it, these are the countries that brought a case against South Africa in the Southwest Africa cases, on the basis that they were the only two black African states that were members of the League of Nations. And this is because of the jurisdictional question. Had a lot to do with you had to be a member of the League because it was based on a dispute settlement clause in the Covenant of the League of Nations and in the mandate for Southwest Africa, which was established by the League of Nations. And I should also say that on the question of apartheid specifically, India and Pakistan early on had been complaining in the United Nations General Assembly very early on, 1946, 1947, about the treatment of people of South Asian origin was in South Africa. And at that time it was seen as controversial because the whole idea of human rights was still something quite new. So the point I'm trying to get at here is that because of Zafarullah Khan's personal involvement and background and support for decolonization and self-determination, he would come to the he would be elected or nominated to the International Court of Justice. It was a history and a background that was not shared by some of his other colleagues, such as Sir Percy Spender, who I turn to next. Now, Sir Percy Spender was in many ways like Zafarullah Khan. He was the Minister for External Relations of Australia before he was a judge at the International Court of Justice. And in that role, he did not see eye to eye with Zafarullah Khan on many colonial questions. He had spoken out in favour of the White Australian policy in the late 1940s. He had opposed the draft Declaration on International Covenants on Civil and Political Rights, and particularly the Common Article 1 that spoke of a right of all peoples to self-determination. He said that was a political idea that didn't have any place in a human rights covenant. He clashed openly with Zafarullah Khan on the debates on the independence of Morocco, when Zafarullah Khan asked Sir Percy Spender, why does Australia always side with the colonial powers on colonial questions? Isn't an issue about human rights? And Sir Percy Spender was offended and said, I always defend Australia's human rights record. But you could see that there was an issue there. And we can see this coming to a head also in the Right of Passage through India case, which was about the right of Portugal to move goods, people and arms and traffic between Goa and some Portuguese enclaves within the Republic of India. And in that case, Sir Percy Spender had criticised India's actions, whereas Zafarullah Khan had said there was no breach of international law in India preventing the passage of arms between the enclave and Goa, because it was in pursuit of eradication of colonialism, which he saw as legitimate in contrast to Sir Percy Spender. There was another issue why Sir Percy Spender was concerned with Zafarullah Khan's views, and that was peculiar to Australia. And I mentioned New Guinea. The fear was that if as we shall see, Ethiopia and Liberia did have a right to bring a case against South Africa for the administration of its mandate to Southwest Africa, then perhaps another country could do the same with regard to Australia's mandates. And in fact, in the Northern Cameroon's case, Sir Percy Spender mentioned this point explicitly. And the Northern Cameroon's case was a similar case about British decolonization, when the north of the Cameroons joined Nigeria against the wishes of the president at the time. They lost that case though. Let me turn to Sir Gerald Fitzmaurice. Now, Sir Gerald Fitzmaurice is quite a legend in this country for being, for the number of articles and books and very long judgments he gave when he was a judge at the International Court, and before then a prominent legal advisor in the Foreign Ministry. And he's also well known for his opposition to the war in Suez in 1956. So he's seen as a hero in that respect. But in South Africa, he took a quite, if you like, dogmatic view or understanding of law, and he consistently opposed the cases against South Africa. I mentioned, of course, Central African Federation, there was Cyprus, then there was Kenya, and there was Southwest Africa, of course. And each one of these, Sir Gerald Fitzmaurice was asked to give legal advice when he was a legal advisor to the Foreign Office. So all of them, Percy Spender, Fitzmaurice, and many of the other judges, in fact, such as Padilla Nova, and others in the South West Africa cases had all played roles in which they were either, in the case of Zafarullah Khan, overtly giving public speeches, so his stance was known, or more surreptitiously, like Fitzmaurice, giving legal advice, which was not public knowledge, but stressing the same issue. Let me read out to you that telegram I mentioned right at the beginning, that piqued my curiosity, so I discovered it in the archives, and which prompted this journey down this path. So earlier I mentioned that when Zafarullah Khan was nominated, or being considered by the British government to join the International Court, Fitzmaurice had expressed strident opposition to that. And I should point out this was quite striking and surprising to British Foreign Office officials who supported Zafrulla. In fact, Fitzmaurice's predecessor, Eric Beckett, had said in 1946, when he was running as a candidate for a united India, had said that Zafarullah Khan was by far the best judge from what they called the Mohammedan and Middle Eastern bloc. But things had changed by 1954, when I argue it had changed because of Zafarullah Khan's open statements against colonialism at the United Nations. So this is what Fitzmaurice wrote to his colleagues in New York. He complained that Zafarullah Khan was not a man, quote, with a judicial and balanced approach to things. He complained that Zafarullah will not be amenable to anyone's influence. In fact, we should think that he will be extremely difficult to influence. In contrast, the other candidate at that time who was competing against, called Dr. Powell, Justice Powell had played an important role in the Tokyo tribunal, was his dissentient opinion, which upset the Americans. He said, in contrast, Dr. Powell, so in contrast to Zafrulla, quote, has been a colleague of Professor Lauterpax on the International Law Commission, and except perhaps on directly colonial issues, might well be influenced by him or by some of the other better judges. And he then goes and lists the judges, such as Bastevant of France, Kleistad of Norway, and Reed of Canada. Fitzmaurice went on to write, quote, if there is to be an indifferent judge on the court, it is perhaps better, within limits, to have someone who will at least pay some regard to what his betters may think, than someone who will obstinately adhere to his own view in all circumstances. In other words, they wanted someone who perhaps wasn't so independently minded on the court, and they were concerned about Zafarullah Khan being a judge in this respect. And it's interesting because Justice Powell was in fact, Zafarullah Khan got elected in the end, despite Fitzmaurice's objections. And what's intriguing is that Justice Powell, as I mentioned, who had written the dissentient opinion in the Tokyo Tribunal, comparing the Americans to the Nazis in World War II, was fine for the British Foreign Office, but not the Americans. And in fact, by that time, the Americans were the major players in international politics. A lesson that Zafarullah Khan had learned from his failure to get elected the first time round, and he won. He got elected that case. And one issue we need to be aware of, so this is a picture of Zafarullah Khan with JFK, is that United States' position on colonial questions starts to shift in the late 50s and early 1960s. The US was never formally a colonial power. I know they have possessions that were acquired at the high period of imperialism, such as Hawaii, Puerto Rico, and the Philippines, but they were not, by the 1950s, seen in the same light as Britain and France, for instance. And America's shifting for several reasons. A lot of those reasons have to do with the state of race relations within the United States at the time, and civil rights activism, and also the Cold War, because the Soviet Union begins to shed light on the fact that there's racial segregation being practiced in the United States, as there was in South Africa. And in 1960, we have 17 colonies becoming independent. Whose side are they on in the Cold War? Are they on the side of the liberal democracies, or are they on the communist camp? And And at that time, the Americans were concerned because a lot of these ambassadors would go to New York, and when they travel around the country, in some states, they would be traveling on segregated buses, or their children would have to go to segregated schools or restaurants or any public convenience. And so the State Department begins to shift its position, and so does America. And in many ways, Zafarullah Khan would benefit from this shift on this particular issue of decolonization. And we can see this also in Judge Jessup's opinions in the South West Africa cases, one of the dissents. And so the UK, South Africa, and France, beginning in the 1960s, become isolated at the United Nations. This is a picture of Ernest Gross and Mossadegh, the first elected Prime Minister of Iran, who nationalized the oil industry only to be overthrown in a coup in 1953, I think. And it was a speech that Zafarullah Khan gave in support of nationalization that initially upset Fitzmaurice. In fact, at the time, Zafarullah Khan was nominated for a Privy Councillorship, and it was because of that speech that he didn't get it. There's a whole file just on his nomination at the archives in London. Now, Ernest Gross was a State Department official, an American citizen, and he becomes the chief counsel, the main lawyer, bringing the case against South Africa on behalf of Liberia and Ethiopia. And it's no coincidence that the Americans take an interest for the reasons I've already explained. This is the 1960s, so his more junior lawyers are some famous names for those of you who study international law. People like Richard Falk, Arthur Roving, and Anthony de Amato were the junior counsel involved in preparing the pleadings and the written statements. And it's also around this time when the trouble begins. I just want to check. When he's asked by Ernest Gross, Zafarullah Khan is approached to become judge ad hoc, but I'm going to talk about that in more depth shortly. So let me turn to Southwest Africa. Southwest Africa, which is now called Namibia, as you can see, is highlighted in green on this map, and it literally is in the southwest of Africa. Well, the German colony, and after Germany lost the First World War, His Britannic Majesty took control over the territory, but because of its geographical propinquity, contiguity to South Africa, Britain asked South Africa to administer Southwest Africa as a mandate. So after the First World War, the League of Nations was established, and the principle of non-annexation was first mooted. So the idea of land swaps, something that was condemned, wars fought in the name of the balance of power, was condemned, and instead this latent idea of self-determination began to be articulated, but was going to be nurtured through this idea of trusteeships. So it wasn't something that all peoples had a right to, it had to be acquired. I'll say more about this shortly. Now, the South, when people mention Southwest Africa cases, they're referring they could be referring either to the two judgments based on cases, decisions delivered in 1962 or 1966, or they could be referring to the whole lot, which includes those two decisions and 4 advisory opinions. So an advisory opinion is different to a judgment in the sense that it's advice given by the court to the organ that requests this advice. In this case, it was always the United Nations General Assembly. And the court, of course, is articulating what the law is when it does that. But it's not formally binding in the sense that it's between two states that have agreed, that have consented to jurisdiction before and will abide by the finding of the court. This is why also the attempt to move towards bringing a contentious case was mooted in the late 1950s because of the failure of the Free Advisory Opinion of 1950, 1955, and 1956. And then after the failure of the contentious cases, there was a further advisory opinion in 1971 that was drafted in large part by Zafarullah Khan. So mandates, the mandator had a right of administration, not sovereignty. That's the main issue you have to understand. So let me speak about the League of Nations. And I'll briefly just reread the main provision, which is Article 22 on mandates, and then I'll explain what South Africa, the provision applicable to Southwest Africa. And the importance of doing this is so we can see the shift in the law that happens in the 1960s when the United Nations issues a declaration condemning colonialism. You can see that it's in opposite to this idea of trusteeship. So I explained that Southwest Africa was a C-class mandate as opposed to Palestine, which was an A-class mandate. This idea of A, B, and C mandates corresponds to paragraphs in Article 22. A mandates referring to communities formerly belonging to the Turkish Empire, B-class mandates referring to those in Central Africa, and C-class mandates referring to Southwest Africa and certain South Pacific islands. So Article 22 begins as follows. So those colonies and territories which as a consequence of the late war have ceased to be under the sovereignty of the states which formerly govern them, and which are inhabited by peoples not yet able to stand by themselves under the strenuous conditions of the modern world, there should be applied the principle that the well-being and development of such peoples form a sacred trust of civilization, and that securities for the performance of this trust should be embodied in this covenant. The best method of giving practical effect to this principle is that the tutelage of such peoples should be entrusted to advanced nations, who by reason of their resources, their experience, or their geographical position can best undertake this responsibility and who are willing to accept it. And that this tutelage should be exercised by them as mandatories on behalf of the League. And then they go through the different paragraphs I have mentioned already. And the applicable one that was with regard to Southwest Africa, that owing to the sparseness of these territories, small population, small size, and their remoteness from the centres of civilization, or their geographical contiguity to the territory of the mandatory and other circumstances, were best administered under the laws of the mandatory as integral portions of its territory, subject to the safeguards above mentioned in the interest of the indigenous population. So a large chunk of the contentious case in 1962, particularly 1966 judgment, although the court never addressed it, was whether South Africa was administering the mandate in a manner that was consistent with this notion of a sacred trust of civilization, and whether the well-being and development of such peoples was safeguarded through the apartheid system. But of course, in the 1960s, when these cases come before the International Court, the League of Nations had been dissolved. And so the first question that arose, one of the first questions that arose is what would happen to the mandates? Would they become independent? Such as Lebanon, as Syria, as Mesopotamia or Iraq had become, and Transjordan, or what is now Jordan, would become? Or was there an obligation to establish United Nations trusteeships for them? So when the League of Nations was dissolved and the United Nations was established, the United Nations also created a system similar to mandates, but they called them trusteeships. But it was not clear if there was an obligation following the dissolution of the first international organization and the creation of the second international organization, whether there was an obligation in the interim for existing mandatory powers to automatically transfer them. Basically, South Africa didn't want to do this. South Africa wanted to annex the territory in order to maintain its hold over it. and to apply its laws to that territory. And so the ICJ held that South Africa could not do that. It could not alter the status of Southwest Africa without the consent of the United Nations, and that it had an obligation to report on its administration to the United Nations, as it had done previously to the League of Nations Council. It also held that, and this is important, it also held that the dispute resolution clause in the mandate was still in force, and that the International Court of Justice had replaced the Permanent Court of International Justice, which is the court established under the League of Nations. It was divided on the issue of whether there was an obligation, however, to convert, whether countries already administering mandates had an obligation to establish trusteeships for them. 6 of the judges said that there was an obligation. Most of them said there wasn't. Of course, South Africa refused to, or ignored the opinion, and ignored all the other opinions that were given that related to Southwest Africa. Zafarullah Khan was involved in the 1955 and 1956 opinions, which was about the right to petition to the United Nations. And it was in this context, in the failure of, if you like, South Africa to abide by opinions of the International Court of Justice, that a group of lawyers in the late 1950s, early 60s, I mentioned Ernest Gross, came up with the idea of a test case, if you like, trying to bring a contentious case against South Africa. And the states that would do this would be Ethiopia and Liberia, because they were the only African members, black African member states of the League of Nations at the time, to whom this dispute settlement procedure applied. So the idea was that they would rely on this clause to take a case against South Africa on the basis of its conduct of the mandate. Now, before I explain a little bit more about that decision, a little bit of context is in order. Because something happened in the 1960s, and that is the passage by the United Nations General Assembly of the famous Declaration on the Granting of Independence to Colonial Countries and Peoples. Now, I read out to you Article 22 of the League of Nations Covenant. And if you compare that language to the language that was adopted in 1960, we can see that there's a different flavour, if you like, in the United Nations. And the 1960 Declaration declares that the subjugation of peoples to alien subjugation, domination and exploitation constitutes a denial of fundamental human rights. It's contrary to the Charter of the United Nations and is an impediment to the promotion of world peace and cooperation. It then goes on to state that all peoples have a right to self-determination, which has never been mentioned before in so explicitly in any UN document. I mean, it's mentioned in the principle of self-determination is addressed in the UN Charter, but it's not given any content until this. And this is also key because this provision is then taken out and almost put verbatim into the Human Rights Covenants of 1966. Importantly, it says that inadequacy of political, economic, social or educational preparedness should never serve as a pretext for delaying independence, which seems to go contrary to the idea of trusteeship with an advanced power having tutelage over states. And then the decision as to whether the people of a territory are ready for independence is something that's for the colonial power to decide rather than the people. And then there's a provision saying prohibiting the partial or total disruption of the national unity or territorial integrity of the country, which arose in the following the Second World War, in Korea, Palestine, Germany, India, Cyprus at the time. There was a big debate, Katanga, and then of course the Bantustans, or the African homelands, which I'll address at the end of this talk. And another issue, of course, is what status in law do we give this kind of declaration? Is it signifying that the law, international law, has changed? And if international law has changed, what law do you apply when you address an issue about whether, for instance, apartheid is lawful or not in the 1960s? Do you apply the law that's being influenced by this new third world movement, or do you apply the law that existed at the time when the mandates were established, namely the 1920s? And as you can imagine, the judges take a different view on this. Just to put some more context behind this, this is a picture of Fidel Castro with Malcolm X at the Hotel Teresa in Harlem in November 1960. Fidel Castro and Malcolm X are in New York for the United Nations General Assembly when this declaration is adopted, and of course making the link between US racial segregation and the decolonization movement kind of coming together as allies. Fidel Castro and Khrushchev meet for the first time at the United Nations General Assembly when this declaration is adopted. In fact, it's the USSR that places the declaration on the agenda of the UN General Assembly. Also, in 1960, earlier, before the UN convened, but the same year, we have Sharpeville. The South African police shot dead 69 African protesters. When Harold Macmillan spoke of wind of change sweeping Africa, when 17 former colonies were scheduled to become independent and join the United Nations. The year when the African National Congress was declared an illegal organization under the Suppression of Communism Act in South Africa. And when the following year, in an all-white referendum, South Africa votes to end its ties with the British Commonwealth. Also in South Africa, we have the treason trial. Nelson Mandela's on trial with another 155 people for high treason, for opposing racial discrimination. In his autobiography, Long Walk to Freedom, Mandela explains that he was influenced by the Cuban Revolution of the previous year, the Chinese Revolution of 1949, and had read works by Che Guevara, Mao Zedong, and Fidel Castro. And at this time, Zafarullah Khan is, a year following this, he's elected the President of the United Nations General Assembly. What that means is he's chairing a lot of these debates, a lot of these discussions. He's not participating. But you can imagine that if you're a judge sitting in The Hague and you're hearing all this news about all these radical and subversive movements suddenly becoming involved in United Nations politics, you're already on the record criticizing Zafarullah Khan in the context of his support in the late 1940s, and now he's the President of the United Nations General Assembly. Some of the judges start to get a little bit worried. They particularly get worried when Ethiopia and Liberia, or the agent for Ethiopia and Liberia, approaches Zafarullah Khan and asks him to sit as a judge ad hoc in the contentious first phase of the South West Africa cases. So the International Court of Justice has usually 15 judges, supposed to represent the differing civil and legal systems of the world. But sometimes it was foreseen that in order to encourage states to make use of the International Court of Justice, states have to consent, and some states might not like agreeing to a case before the International Court of Justice if they do not have a judge of their nationality on the court. If the other party does, it would be seen as unfair. So the idea of a judge ad hoc to address this issue was established. Judge ad hoc does not have to be of the same nationality, but he might be seen as a judge who, for various reasons, might be considered more favourable to one party because perhaps of judgments in previous cases or his speeches or his writings. So in this case, the agents for Ethiopia and Liberia approached Zafrulla Khan and asked him if he would sit as judge ad hoc in the first phase of these cases, which concerned the jurisdiction issue. Now what happens, and this is where it gets interesting, and I know, and this is where the story of the Recusal really begins, 1962, but you can't understand any of this without understanding everything else I've told you. So it transpires from Sir Percy Spender's personal papers, many of which are copies of letters and internal deliberations, and even the score sheet of decisions from the International Court, which he kept in his personal possession, didn't destroy them, and then they're sitting there in the library in Canberra. That it was Percy Spender who first raised the issue of the appropriateness of having Zafarullah Khan sit as a judge ad hoc in the first phase of these cases because of his association with all these nefarious activities at the United Nations. And so, from reading these papers, it transpires that he persuades his fellow judges to have a meeting and discuss this. And various views are canvassed, and the judges decide that the best course of action is to write a letter to Zafarullah Khan asking him if he thinks that there's any incompatibility with his current function as a president of the UN General Assembly and being a judge in this, judge ad hoc in this case. So Zafarullah Khan receives this letter and he writes a very long reply explaining why, as soon as he was approached, he told the government of Pakistan that in view of his desirability to sit as a judge ad hoc, he would have nothing to do, wants to have nothing to do with any discussion of Southwest Africa in the United Nations. And then he goes and explains that, as a chairman, his role is only vicarious, he's not directly participating or taking a stance in any of the issues. Sent back, the judges read it, they again have different opinions. But Sir Percy Spender and Fitzmaurice are like, no, he's definitely involved. There's no possible way he's definitely against South Africa. There's no way he can be, against the applicants. We can't have him. So, but the judges don't all agree with that. Judge Tanaka, Judge Jessup, others are, we also, Jessup participated in Security Council debates, for instance, when he was an American ambassador. So he says, no, it's not. Just because you're at the UN doesn't mean that you're involved in all these debates. So what essentially the short letter is written by President Viniarski and sent to Zafrulla, and it says, we leave it to your discretion whether to sit in the case. And so Zafrulla reads this and seems to think, well, it's not exactly a voting confidence in me, but, they're clearly uncomfortable, that's why they've written to me, so I won't insist, so I will not sit. So he doesn't sit as the judge ad hoc in the 1962 case. And this is really important because this is a prequel to what happens in 1966. So in 1962, in a very narrow decision, the International Court says it does have jurisdiction. So South Africa challenged the Ethiopia and Liberia's claim to bring a case against South Africa on the basis of this clause in the mandate, which if you just read the clause, it clearly gives them jurisdiction. The minority view was that this has to be read in the context in the light of the 1920s, and it was never envisaged that it would allow another member of the League of Nations to sue a mandatory power for its operation of the mandate as such. It was designed just for disputes concerning the interpretation of an agreement. But the majority, in narrow decision, held no, in the plain and ordinary meaning, didn't limit it to that kind of dispute. So, between 1962 and 1966, 4 years, volumes of reports, 2 years of oral arguments. South Africa is defending its record of apartheid. So this is not contrary to international law, what we're doing. It's analogous to other countries in the world that make differences between citizens. They come up with various debates to show that discrimination in certain cases can be lawful, whereas the lawyers for the applicant are, making the opposite argument and saying, international law has evolved by the mid-1960s. there is such a thing as racial discrimination in international law. We have to remember that at this point there is no only 1965 is there a convention outlawing racial discrimination. So when they begin these cases, there isn't even a convention, and of course that's because a convention is finally drafted and open for signature. Doesn't mean that it's binding, unless you can argue that it's custom or a general principle of law. But in the 1960s, there are lots of other human rights treaties, the International Covenant on Civil and Political Rights, economic and social and cultural rights, this idea of self-determination, but it's all still in draft form, and in draft form, of course, being opposed by Fitzmaurice and Percy Spender when they were ambassadors. But the point here is that everyone is expecting the court to deliver a judgment on the merits. In other words, on whether apartheid is contrary to international law. So everybody's surprised when the court instead seems to give a judgment on jurisdiction, despite the 1962 saying that they have jurisdiction. The 1966 court says that that the applicants don't have any interest, are not directly affected. They have no interest in the outcome, and therefore the court doesn't have jurisdiction. Therefore, there's no need to look at the issue of whether South Africa's apartheid policy is contrary to international law, or whether the operation of the Mandate's Covenant is contrary to the Covenant of the League of Nations or international law as it has evolved since then. There were many dissents. Judge Tanaka, Jessup, Wellington Koo, Koretsky, and Padilla Nerva and the Judge ad hoc all opposed this issue. Judge Tanaka goes to the extent of actually looking at the issue and says that racial discrimination reaches a conclusion through general principles of law and customary international law, that racial discrimination is in fact contrary to international law. And they're admonished by Percy Spender, you're not supposed to do this. This is my case, I'm the president. And what was so controversial, apart from the fact that they don't address the merits at all, despite the lawyers having spent 2 years investigating these cases, is that he's only able to reach this decision because he had 2 votes. As president, when there's a tie, you get a casting vote. So you get your vote and you get an extra vote. And then the reason why it's split is due to the death of one judge, the illness of another, and then the disappearance of Zafarullah Khan. So everybody's like, well, where's Zafarullah Khan? Because we would have assumed that he would have sided with the Ethiopia and Liberia against South Africa. So the Observer newspaper in London calls him up, and he basically explains, that Sir Percy Spender, so he was elected in 1964, so Percy Spender's the president at this stage, calls me into his office and says, I don't think you should take part in these cases because you refuse to sit as a judge ad hoc. Of course, I probably didn't know that the letter that was sent to him was originally, concocted by, pressured by Sir Percy Spender. But, and of course, Zafrulla as well, the reasons why I explained in my letter to the court why I thought I had the right to sit, and the reason why I didn't sit was not because, I participated in the issue that was germane to the case. I didn't have any direct participation in any of the issues concerning South West Africa, which could be a ground for not being able to sit as a judge. And so they had this toing and froing. And but Sir Percy Spender's there's a clause in the statute of the International Court of Justice, which sets out the qualifications when a judge should recuse himself. And so Zafarullah Khan was making the point that this wasn't applicable to him. There's another clause in the statute that says if there's a dispute between 2 judges on this issue, it is to be resolved by the court. In other words, the vote. So Sir Percy says, okay, well, I'm going to put it to vote. But he doesn't. But he says verbally, in the closed door, majority of your colleagues don't think you should sit on the case. But he's not willing to say, to take it any further than that, and to actually put it to a vote. It turns out only him and Fitzmaurice were the ones who were opposed to Zafarullah Khan sitting on the case. And so you have this toing and froing, these letters, these meetings, and it's clear at this stage Zafarullah Khan, and he's got friends in the court, speaks to people, speaks to the registrar, And he realizes that this is a bit of a dirty tactic on the part of Percy Spender. And so 1965, Percy Spender says, I want the letter, you resignate, not the resignation, but I want a clear letter from you saying that you're going to recuse yourself. Comes back from his holiday, finds this letter, and says the opposite. So, or it kind of says, the letter says, I will, because of what you say, I won't take part in the case. However, I'm not recusing myself because I don't think there's any conflict of interest. So Percy Spender writes back and says, no, that's not good enough. I need a commitment from you. He doesn't get it. So Zafrulla doesn't take part in the case. The issue is confusing because there was also an attempt by South Africa to dismiss another judge on similar grounds, as Padilla Nervo. And there was an order given by the court in 1965. They don't mention who the judge is. So a lot of people writing at the time, some scholars assumed it was Zafarullah Khan. But it wasn't, because when you count them up, you realise that Zafrulla wasn't involved at all. So of course, people work out that something's happened and it's not quite right. Something fishy is going on. And the judgment, of course, is, the African countries have invested lots of hope in these cases, a lot of hope in international law. So they're furious. So the UN General Assembly attacks the court. This is a white man's court. Percy Spender is attacked in very violent language by various ambassadors in the United Nations General Assembly. The United Nations General Assembly revokes South Africa's mandate over Southwest Africa, which could be legally questionable whether it could have done that, but they do that. They stop funding ad hoc judges to the International Court, and they threaten to stop funding the courts further, which caused a lot of worry, obviously, on the part of the court. The court's boycotted. If you look at the late 60s, early 70s, there's hardly any cases. Hardly any countries are using the International Court of Justice. Southwest Africa was renamed Namibia in 1968. And as I mentioned, the US position shifted. By the late 70s, Civil Rights Act has happened, Martin Luther King's been assassinated, and the US no longer sees the need to protect South Africa over this particular issue. And so, in 1970, the UN Security Council calls on South Africa to terminate its occupation of Namibia, which of course the Council can only do that with a concurring vote of the United States. South Africa ignores the Security Council, as it ignored the International Court, as it had ignored the UN General Assembly. And so the UN Security Council this time, not the General Assembly, requests an advisory opinion from the International Court of Justice on the legal consequences of South Africa's presence in Southwest Africa, notwithstanding adoption of that resolution. In the meantime, 1970, Zafarullah Khan is elected the president of the International Court of Justice, and is elected the president of the International Court of Justice in an election which is competing against two judges, one of which is Sir Gerald Fitzmaurice. And essentially the 1971 opinion is what many thought the court would have reached in 1966. So the court expressly recognizes the right of all people to self-determination, a word that was conspicuous by its absence. Never mentioned before. It refers expressly to the opinion refers expressly to the United Nations General Assembly, Declaration on the granting of independence to colonial countries and peoples, which I mentioned earlier, spoke of self-determination. He said that international law and instruments that were, established during the formative period of colonialism have to be interpreted in light of subsequent developments and the progressive development of international law, namely human rights and resolutions on decolonization. So Namibia has the right to independence. It's a UN General Assembly resolution that terminated the mandate was lawful, and the UN Security Council resolution that called on South Africa to terminate its occupation of Namibia was binding, even though it wasn't adopted under Chapter 7 of the UN Charter, which is quite novel. Usually that's the standard view. And it also called on states to terminate relations with South Africa in relation to Namibia. Fitzmaurice predictably wrote a 200-page dissenting opinion. He was actually attacked by a left-wing member of the House of Commons for doing that. The British government was astonished by this opinion. They were very upset. They rejected the advice of the International Court of Justice. For many reasons, Britain still had a lot of mining interests in South Africa and Southwest Africa, such as the Rio Tinto company, as it was then called. And so the argument I make in the article is that 1971 Namibia opinion is largely Zafarullah Khan's opinion, the language that was used in the opinion. And also I draw some similarities with a speech he gave on Palestine, which was on the mandate and the kind of way he interprets the League of Nations mandate to signify eventual independence. Zafarullah Khan publishes declaration, very rarely did that, and he alludes to South Africa's policy of the homelands. This in many ways is a reaction to the international to developments of the International Court of Justice. This is a map showing Namibia, and you can see these are various homelands. And to get around the argument that South Africa was pursuing racial policies, or discriminatory racial policies, South Africa in the 1970s started to argue it's a nationality problem. These aren't races, these are nations. And each nation will have its own homeland. And eventually, each homeland, like the trustee, like the UN trust territories, will be in time become independent states. And also they did this was in South Africa itself, with the Transkei being one of the first homelands to be declared independence, but the United Nations General Assembly and the Security Council refused to recognize them as states. And of course, South Africa kept the bulk of the land, the best minerals, best farming land, etc. That's why it was always, and that were the issues that Zafarullah Khan criticized in his, what he called his declaration. We can see that eventually all Africa and most African countries are admitted to the United Nations in the 50s, 60s and 70s. Namibia becomes an independent state in 1989, and I think it's significant that Namibia becomes independent before apartheid in South Africa is dismantled. It was one of the arguments that the lawyers for Ethiopia and Liberia made in the 1960s, and that was a reason why they attempted to get a judgment against South Africa, was that if they could get a judgment from the International Court of Justice that apartheid was unlawful within Southwest Africa, then that argument would be equally valid with regard to South Africa itself. So I'll leave my talk there, and I'm happy to take any questions that you have. Thank you.